September of 1983, police detained a man that was parked illegally on the side of the highway. This man's name was Larry Eiler, and quickly after learning this, police arrested him and searched the illegally parked truck. Upon searching the truck, police found a treasure trove of incriminating evidence against Eiler because he was suspected of he was a murder suspect in the murder of a man named Ralph Calise. So upon searching this vehicle, they found a treasure trove of evidence against the man, including but not limited to a knife with the blood of the victim on it, all but proving Eiler's guilt. However, police had to let him free. The court utilized the infamous exclusionary rule, and because of that, Eiler was set free. Not because of the evidence against him. No, the evidence against him was actually overwhelming. However, they used the exclusionary rule and he was set free. It's cases like this that defy every basic standard of morality and common sense. And it's because of that, because murderers ought not be let free on technicalities, that justice demands the affirmation of the resolution that criminal procedure should value truth-seeking over individual privacy. Now, before we get into the main arguments, we need to be clear on the terms that we're using, so we'll start with the definition. Criminal procedure is defined as, quote, defined by U.S. legal as, quote, the laws and rules governing the mechanisms under which crimes are prosecuted, investigated, prosecuted, adjudicated, and punished. Privacy is defined by the Business Dictionary as, quote, in general, the right to be free from secret surveillance and to determine whether, when, how, and to whom one's personal or organizational information is to be revealed. With that, let's jump straight into the value, and that value is going to be justice. Again, justice. Justice is defined as giving each person their due. In the context of criminal procedure, giving each person their due means holding the guilty accountable for their crimes, as well as protecting and exonerating the innocent. And the one reason we speak using justice is that it's the purpose of criminal procedure. The purpose of criminal procedure. Criminal procedure necessitates and implies that justice is done. It's because of this that justice is the best weighing mechanism for the round, because it's the foundational reason why we have criminal procedure in the first place. My contention one is prioritizing privacy obstructs justice. Prioritizing privacy obstructs justice. While privacy is an essential right, all rights need limits. Privacy is great, but when it conflicts with truth-seeking, we ought to prioritize truth-seeking. And the application here is application one, the exclusionary rule. In the exclusionary rule. Almost 2 centuries after the founding of the United States, the Supreme Court made a groundbreaking decision regarding criminal procedure without a shred of basis within the Constitution or empirical evidence to prove its logical ability to work in the real world. That decision was Mapp versus Ohio, which made the exclusionary rule the law of the land in the United States. But what is the exclusionary rule? Well, the exclusionary rule requires that any evidence, no matter how important to conviction, for any crime, no matter how heinous, must be excluded from the court if the seizure of that evidence is later found to be illegal in any way. To say that this law has been unpopular with originalist judges is a massive understatement. Iconic justices like Cardozo, Scalia, and Thomas have all expressed their beliefs on the unconstitutionality of this rule. Recently, Justice Thomas wrote in his opinion on Collins versus Virginia, quote, the exclusionary rule appears nowhere in the Constitution, postdates the founding by more than a century, and contradicts several long-standing principles of the common law. The founders would not have understood the exclusionary rule. The impact is it destroys justice. Once again, it destroys justice. The exclusionary rule is a modern invention that prioritizes privacy and lets the guilty get away with crimes. And I have an actual statistic that shows us the real impact of that exclusionary rule. And it says that according to Steve Schlesinger, who's the director of the Bureau of Justice Statistics, as well as the Federal National Institute of Justice, they have all respectively estimated that up to 55,000 serious crimes, including 1/3 of all drug cases, are dropped each year in our country because of the exclusionary rule. What's worse is an Institute study found that half of those that were set free were rearrested for separate crimes within 2 years. What we see is a massive impact to justice, not only the failure to punish the guilty, but also the failure to protect the innocent. My second contention is truth-seeking achieves justice. Truth-seeking achieves justice. When truth-seeking is given priority, the innocent are protected and the guilty are punished because the system is allowed to do its job. And the application here is Utah versus Strife. Utah versus Strife. Edward Strife was detained by police and asked to identify himself after being suspected of drug possession. After discovering that Strife had an outstanding warrant for a separate incident, police arrested the man and found that he was in fact in possession of drugs. However, the story can't possibly end there, can it? The defense argued that the initial stop was not based on enough probable cause, and therefore the methamphetamine found on Strife had to be excluded, letting yet another guilty person go free. But the Supreme Court actually overruled the Utah State Supreme Court decision to implement the exclusionary rule, and in a 7-2 decision decided to use the evidence against Strife because not using it would be an impediment to justice, and using the exclusionary rule would not deter any police misconduct. So what happened to Larry Eiler after he was set free? Well, he moved on and found his next victim, a 15-year-old boy named Daniel Bridges. This kind of injustice is gut-wrenching, but it's the inevitable outcome of it. And that's the
Starting off with a general question about the resolution. Should police be allowed to violate the Constitution?
Generally, no.
Generally, no. Okay, so you think there are times where they should?
No. When I say no, I mean no.
Okay. They shouldn't be allowed. Okay. And can government take truth-seeking too far?
Sure.
Okay, and does truth-seeking do anything to restrain the government's power?
Not truth-seeking itself, no.
Okay, thank you. Let's go into your value of justice. So is catching the guilty an essential aspect of justice?
Yes, punishing the guilty and protecting the innocent are both essential aspects of justice.
Okay, and you talked about the exclusionary rule, so you'd agree that if a law helps the guilty go free, it harms justice, correct?
Yes.
Okay, thank you. And is it your position that we should pursue justice at all costs?
No.
No? Okay, so then there are things that are more important than justice?
No, because you asked about the means. Justice is the ends, but so we have to be doing so in a moral way.
Okay.
But yeah, justice is the goal. It's the ultimate goal.
Okay, thank you. And as the negative, do I need to prove that privacy should never be violated?
No, we're not talking about an absolute resolution.
Of course. Okay, thank you. And going on, you talked about the exclusionary rule. So specifically, in your opening example, what rights specifically did the police violate that warranted the exclusionary rule?
So according to the Illinois State State Courts, the reason why the exclusionary rule was implemented was because of the same reason in Utah versus Strife. They detained him and they knew he was a murder suspect, but they didn't have enough probable cause, even though he was illegally parked by the side of the highway.
Okay, and it's your position that the exclusionary rule, it does more harm than good, correct?
Yes.
Okay, thank you. And let's talk about actually with just the Fourth Amendment as a whole. So can government seek the truth without a warrant?
Yes.
Okay, so then the purpose of the warrant requirement is not truth-seeking, correct?
The purpose of the warrant requirement would be to get a warrant, but the purpose of the warrant would be to search something.
Okay, and if police violate the Fourth Amendment in pursuit of the truth, is it not still truth-seeking?
Could you repeat the question?
If the police violate the Fourth Amendment in pursuit of the truth, is it not still truth-seeking?
No. Yes, I guess it would still be truth-seeking, just because truth-seeking can happen doesn't mean that's what I'm talking about,
Right,
but yes, that would be truth-seeking.
Okay, thank you. And in Utah versus Street, did they decide to admit the illegal evidence or not?
Yes, they did decide to admit the illegal evidence.
They did. And what was the doctrine under which they decided to admit this?
Well, first, that using the exclusionary rule wouldn't actually deter any misconduct because of what happened, and then secondly, that not using the evidence would be an impediment to justice.
Okay, so is this the good faith exception to the exclusionary rule, or what specifically was it?
No, it's not an exception to the exclusionary rule. It's just this time that they chose not to use it.
All right, thank you. No further questions. judges are ready. British historian Sir John Acton once said that power tends to corrupt, and absolute power corrupts absolutely. And this reality is why I stand resolved that criminal procedure should not value truth-seeking over individual privacy. Now, I'll propose the counter value of liberty as the best way to measure this resolution. Liberty is defined as freedom from oppressive control by an authority. Now, my opponent presented the value of justice, and while I agree to an extent that justice is one of the goals of criminal procedure, I have two reasons to prefer liberty over justice. The first reason is that liberty restricts governments. Liberty restricts governments. It's noteworthy that my opponent said in cross-ex that truth-seeking does nothing to restrict the government. And why is this so important? It's so important because in the words of Founding Father Patrick Henry, give me liberty or give me death. And he was not alone when he said this. Throughout history, millions of people have risked their lives for liberty. Now, this applies specifically to criminal procedure because if catching criminals is your highest goal, you will only empower the police, not restrict them. This leads to reason to prefer number two. Freedom is worth the price. Freedom is worth the price. In the words of Justice Scalia, quote, the Constitution sometimes insulates the criminality of a few in order to protect the privacy of us all, end quote. So the Constitution enshrines the principle that protecting our liberty is worth the price of making criminals more difficult to catch. Therefore, whichever side best achieves liberty should win this round. Contention 1. Valuing truth-seeking highest erodes liberty. Valuing truth-seeking highest erodes liberty. Now, truth-seeking does nothing to restrict the government's power. And if truth-seeking is not restricted by privacy, it will be taken too far, resulting in oppressive invasions on our freedoms. Application 1, the France state of emergency. In 2015, terrorist attacks caused France to declare a state of emergency. France's new criminal procedure code allowed the police to search any property without warrants to facilitate catching terrorists. The next 6 months saw 3,600 warrantless searches and 420 arrests. Sadly, only 2% of these searches led to convictions, and no terrorist networks were dismantled. In the interest of truth-seeking, police would often burst into homes at night, damage property, terrify children, and cause people physical harm and humiliation. The impact of this is that humans by nature are tempted and corrupted by power. When truth-seeking is valued over privacy, the government gains too much power, and liberty erodes. This leads to contention 2. Valuing privacy highest guards liberty. Valuing privacy highest guards liberty because it restricts the government's power to invade our lives. In application 2, the history of the Fourth Amendment. In the 1760s, Britain issued the writs of assistance to catch American smugglers. With these writs, police could search any place at any time in any manner if they suspected contraband. Police would invade houses, destroy property, and harass colonists. Now, in response to the writs of assistance, our founders wrote the Fourth Amendment, which requires the police to obtain a judicial warrant before searching property. The Cornell Legal Dictionary states, quote, the ultimate goal of this provision is to protect people's right to privacy, end quote. We see this further play out in application 3, which is actually Mapp versus Ohio. In 1957, police believed Mapp was hiding a suspect in her home. They demanded entrance into her home without a warrant. When Mapp refused, they forced open her door, detained her, and searched her house. Now, instead of finding the suspect, police found a stash of illegal, obscene photos. Now, my opponent would have you believe that this is a case that is bad, but we have to understand the context of this case. This was an extreme act of abuse by the police, and the court realized that they need to stop this from happening in the future. That is why they made the exclusionary rule. Mapp was clearly guilty, but the Supreme Court threw out the convicting evidence. This set the precedent that if police deny your privacy, the evidence they find is excluded from court. Why is this? Because an abusive government is far more egregious than any crime. In the words of Justice Clark in this decision, he said, quote, having once recognized the right to privacy embodied in the Fourth Amendment, we can no longer permit that right to remain an empty promise, end quote. The impact is valuing privacy highest guards our liberty from the hands of a powerful, corruptible government. With that in mind, let's go into my opponent's case. I already responded to the values, so jumping onto the contentions, I want to make one observation though before I get into those. That is the big picture. The big picture. My opponent has focused on one aspect of criminal procedure, the exclusionary rule, that he would have you believe is bad. This does not prove the general rule that as a general rule, criminal procedure should value truth-seeking over privacy. But I will be responding to the exclusionary rule specifically. He talked about how it's not in the Constitution and how it causes lots of criminals to go free. First of all, with the idea that it's not in the Constitution, my response is built on precedent. Built on precedent. It wasn't just made up in the case of Matt versus Ohio. Actually, several years earlier, in 1914, in the case of Weeks versus U.S., the Supreme Court said this: if illegal evidence can be used against suspects, the protection of the Fourth Amendment, declaring his right to be secured against such searches and seizures, is of no value. It might as well be stricken from the Constitution, end quote. So this is the precedent. It wasn't just a law that was fabricated by the Supreme Court in Matt versus Ohio, but specifically with the idea that it helps criminals go free. He cited a study that said 1/3 of drug cases go free. My response is, again, the actual statistics. The actual statistics. If you look at this study, according to the Chicago Tribune, according to Thomas Davies, a project director of the American Bar Association, he said that study has come in for sharp criticism for concentrating exclusively on arrests that did not lead to prosecutions. When all arrests were figured into the equation, fewer than 1% were rejected because of search and seizure problems. This is very important because of my first response as to why the exclusionary rule is actually good. The cost is minor. The cost is minor. Again, according to the American Bar Association and the Institute for Justice sponsored a study which found that less than 0.6% of 7,500 cases were lost to the exclusion of evidence. So the exclusionary rule has almost no impact on criminals going free. My second response is it deters police abuse. Deters police abuse. The exclusionary rule keeps police from violating the Fourth Amendment. As a result of this rule, after Matt versus Ohio, warrant use in major cities increased from a handful to hundreds per year. So this rule protects our constitutional rights. This applies to Utah versus Street as well. The principle that freeing 0.6% of suspects is worth it to protect everyone's liberties from police abuse. Thank you.
Ready? So let's look back to the resolution. Within today's resolution, you would agree that truth-seeking and privacy should be analyzed within conflict, correct?
Sure.
Okay, and it's your claim that under the Fourth Amendment they are in conflict, right?
Yeah, the Fourth Amendment lays out the conflict very well.
Okay, and you're saying that we prioritize privacy in that instance, right?
The context and the precedent does prioritize privacy, yes.
Okay, so if we look at the actual Fourth Amendment, would you agree, or is it your contention rather, that the police have to get a warrant every time they want to search someone?
No, there are rare exceptions where the warrant requirement doesn't apply. If you want to bring this up, we can absolutely discuss this.
Okay, and then you said that they were rare exceptions. Do you have any reason to believe logically or empirically that they are rare?
Well, again, I don't have any statistics, but just logically, if it's an exception, by definition, it's not the general rule.
Okay, I see. Let's look down to your case where you brought up the value of liberty. And you define that as freedom of, could you actually just...
Freedom from oppressive control by an authority.
I see. So you're saying that essentially liberty should come before justice because liberty protects us from a bad government?
Sure.
Okay, and you're saying also that truth-seeking would lead us to a bad government?
If we value truth-seeking over privacy, yes.
Okay, and then would you agree, did you agree to my definition of justice, right? Okay, so you would agree that within that we're talking about the protection of innocent, correct?
Yeah, it's an aspect of justice.
Okay, what is a right?
A right is something that's inherent to all. Whether you're talking about human rights or civil rights or what specifically?
What would you say is a human right?
A human right is a right that's inherent to all human beings that we have by our nature.
Okay, and if you're innocent and haven't violated the law, should the government respect your rights?
Yeah.
Okay, is that integral to protecting the innocent?
I believe so.
Okay, let's look down to under contention 1. You talked about the application of France state of emergency. So how long did this state of emergency last?
The state of emergency lasted for several years. It was extended after those 6 months.
Okay,
and
and then,
timeline.
okay, and then under the contention 2, you brought up the privacy, and then you brought up the Fourth Amendment, and then you talked about Matt versus Ohio. So when you refer back to Weeks versus U.S. and you say that it was built on precedent, where did that precedent come from?
Weeks versus U.S. I don't know
Yes.
specifically.
You don't know specifically. Okay, and when we look into the Fourth Amendment, or actually let's just expand it to the whole Constitution, is there any mention of anything like the exclusionary rule in the Constitution?
In the Fourth Amendment itself? Or
In the entire Constitution or in the Fourth Amendment?
No, it's not in the words of the Fourth Amendment, no.
Okay, is it implied in the Fourth Amendment?
I would argue yes, it is. I'm glad you gave that.
Okay, where is it implied in the Fourth Amendment?
It's implied in the Fourth Amendment because it guarantees our right to be free from unreasonable searches and seizures, and the only way to protect that is to say police cannot use these searches and seizures to catch criminals with illegal evidence.
Okay, and did you bring up any evidence that says that the exclusionary rule actually deters police misconduct?
Yes, I did.
Okay, and that was just saying that they use warrants more often, right?
Correct.
Okay, thanks. That's really good. All right, I'll be starting. Ready? Let's go back to the value, because I believe that's the paramount issue in today's debate. I know some of you said that we need to be focusing on logic, and I think that it is at the value debate, and then we'll get into the evidence debate, but I think it's at the value debate that the affirmative has the upper hand, and then that trickles down through the rest of the application. So let's look there. I brought to you the value of justice, saying we need to both punish the innocent. No, not punish the innocent. Protect the innocent, punish the guilty. That's what we should be doing. And I talked about how both are equally important. In Caleb's cross-examination, he asked me that, and of course, they're both equally important to criminal procedure. But he brings to you the alternative value of liberty. My first response to liberty, and this goes under his two reasons to prefer, is first, justice protects. Justice protects. You see, an integral part of justice is protecting the innocent, protecting the life, liberty, and property of the innocent. And it's my contention, as I showed you through the exclusionary rule and the 55,000 people a year that are freed, and half of those who are rearrested, that actually it's more of a danger to the innocent, to their rights. It's more of a danger to then prioritize privacy. My second response is half of the picture. What you get with liberty is only half of the picture. When we talk about justice, it's punishing and protecting, but what the negative gives you is only protecting. And then my third and final response is in criminal procedure. In criminal procedure. The first subpoint is subpoint A, limited. Limited. We're not talking about all of society. We're not saying privacy is going to be less valued in all of society. We're just talking about criminal procedure. But then my second response is the purpose. The purpose. When we're looking at criminal procedure, the purpose of criminal procedure is to adjudicate the law. It's to apply the law. And so when we're talking about that, we can't just be talking about only liberty. The law just doesn't talk about liberty and nothing else. It also gives restrictions. So when we're talking about criminal procedure, clearly justice is the best value. It's been achieved by the affirmative and not by the negative. Let's look down to the contention one, where my opponent brings up the application of a France state of emergency. My first response is a limited example. A state of emergency is by definition a limited example. Why? Because it's only for a certain amount of time. Now, he said that it was a couple of years ago, and I know that France isn't now in a current state of emergency. We don't really know the timeline. He had trouble showing me that in the evidence. If he can find it, that's great, but if he can't, either way, the state of emergency, as we have it in all countries, is a limited amount of time. I would say a month or two would be the longest you could expect to see a state of emergency. So this doesn't prove anything about actually a consistent analysis of the resolution. It's just a one-time example. But my second response is empirically denied. He says that if we value truth-seeking, this is what our country will look like, that we'll have all of these kind of warrantless searches, that people will be oppressed. That's just not true when we look at England, when we look at Canada, when we look at Israel, all countries which don't have the exclusionary rule. We can also look to our own country before we had the exclusionary rule. Were we an unjust country for 100 years to 150 years before the exclusionary rule? No, we were a great country. Yeah, we had problems, but the Fourth Amendment was still applied. Let's look down to the application of the Fourth Amendment. My response is Fourth Amendment in conflict. Fourth Amendment in conflict. You see, yes, while we can achieve privacy and truth-seeking with a warrant, we need to be actually looking at the Fourth Amendment when we have to choose. Conflict means we have to choose one thing above the other. If we can get all of the evidence without violating your privacy, go before a judge and say, look, here's the evidence. Now can I go into his property? That protects privacy. But it also gives you all of the ability to truth-seek that you need. So there's no choice. You're doing both fully. The only choice comes when we actually have to prioritize one or the other. And when are those instances? Those are instances of exigent circumstances, of imminent danger, of hot pursuit, of probable cause, all instances where you don't need a warrant to search. That proves the Fourth Amendment prioritizes truth-seeking in conflict. Let's look to the application of the exclusionary rule. My first response is no proof. He didn't bring to you any proof of deterrence, just that warrants were used more. And my second is non-responsive. He talked about how it was built on precedent. It's still not found in the Constitution. It's still unjust, and the judges are still right about it. Thank you.
Insulates the criminality of a few to protect the privacy of us all. And this is a theme that I want to demonstrate to you in this speech, that if we want to follow the Constitution, there is no choice but to prioritize privacy first, even if it comes at the expense of some criminals going free. Let's explain why as we go into the value debate. Now, my opponent was correct in saying this debate in this round is mainly a value debate, so let's get into that. He said, justice protects liberty in half the picture, and in criminal procedure, privacy is limited, and the purpose is for justice. I have a couple responses. First, to his idea that justice protects liberty, my response is justice bypasses liberty. Justice bypasses liberty. The claim that justice includes liberty in reality means nothing, because in reality, truth-seeking can do nothing to restrain the government's power or keep you from oppression. Because the goal of truth-seeking is to catch criminals, to empower the government, not to restrict them. Valuing justice highest ignores the principle that safeguarding liberty is worth the price of making criminals more difficult to catch. He also said half the picture, and I agree to an extent, yes, we should punish criminals, however, not at the expense of liberty. And this is why, this is my second response, also in his response to his idea that in criminal procedure, my response is liberty is still highest in criminal procedure. Liberty is still highest in criminal procedure because only liberty keeps the government from oppressing us, and the government, not a single criminal every now and then, is the most dangerous threat to our rights. According to Supreme Court Justice Stewart, police who obey the Constitution, quote, will catch fewer criminals. That is the price the framers anticipated and were willing to pay to ensure the sanctity of the person, the home, and the property against unrestrained government power, end quote. So once again, I cannot emphasize this to you enough. The Constitution enshrines the principle that even in criminal procedure, guarding liberty is worth the price of making criminals more difficult to catch. With that in mind, let's go on to the France state of emergency. He said, limited example. My response is the timeline is irrelevant. The timeline is irrelevant. Now, yes, the state of emergency isn't there anymore. It was at least 6 months, as the evidence I read in the first speech was. The point here was the principle. The principle was is they saw the warrant requirement as hindering truth-seeking. So they removed the warrant requirement to enable truth-seeking. This is a direct conflict. They valued truth-seeking in conflict, and this led them to remove the warrant requirement. And that is what led to this abuse of people's rights, both physically and emotional damage on these people, on these thousands of people who were searched, most of whom were not criminals. And this again shows how when truth-seeking is chosen in conflict, it harms liberty. He said empirically denied. My response to the debate is not about the exclusionary rule. First of all, this debate is not solely about the exclusionary rule. I mentioned this as my first response to his case, which he actually didn't address. And this shows how even if he proves the exclusionary rule is bad, then that doesn't warrant an affirmative ballot. But also, the fact, I think we need to consider that in America, we take for granted how much we value rights. We take for granted, compared to other countries, how much we cherish our liberties, and we see the price that our founders paid for those. And that is what we need to consider in this round first and foremost. Going on to the Fourth Amendment, he said, in conflict. Now, I agree to an extent that warrants do allow for a very minimal intrusion on privacy, but that misses the point for two reasons. The first reason, and again, both these reasons show a clear conflict. The first reason is the warrant requirement was created for privacy. The warrant requirement was created for privacy. Now, police will naturally truth-seek with or without warrants. This is shown in France and the writs of assistance, where truth-seeking was unhindered. But the warrant requirement uses privacy to restrict truth-seeking. When there is a restriction on something else, that does demonstrate a conflict. This leads to my second response. It values liberty highest. It values liberty highest. In Cross-Ex, we agreed that helping the guilty go free harms justice. And this is where the words of Justice Scalia, as well as the words of Supreme Court Justice Stewart, come in handy, because we see from these justices the idea of the Constitution, of the Fourth Amendment, is that if police obey the Fourth Amendment, the inevitable result of that is they won't catch as many criminals as possible. Justice is harmed. Why? Because they see liberty as the highest value. This is a conflict where liberty is chosen over justice and privacy is used as a priority to restrict truth-seeking. Going on to the exclusionary rule, he talked about no proof. Once again, I don't have any specific statistics about the exact amount of crimes. We can cross-apply and remember the first response is the idea that warrant use in major cities went up from a handful to hundreds per year. And this shows that police follow the Fourth Amendment much more often. And also a second piece of evidence is that actually after Mapp versus Ohio, many more police started actually taking classes on how to follow the Fourth Amendment and how to conduct legal searches. So this absolutely helps police be more professional in their conduct and deter police misconduct. He also did not specifically respond to the piece of evidence I brought up that only 0.6% of criminals are free because of the exclusionary rule. The stat he gave about 1/3 of all drug cases, that was a limited study that has come under scrutiny. According to the American Bar Association and the Institute for Justice, this rule has almost no impact on criminals going free. This leads to a couple voting issues. The first voting issue, only liberty restricts the government. Only liberty restricts the government. And my opponent will come up and talk about how criminals threaten our rights. But I want to ask you, what in this round is the most dangerous threat to our rights? A couple criminals, 0.6% of criminals, or an entire government that has become corrupt because privacy is removed as a restriction? The reality is only liberty can keep the government accountable and limit the government to protect our rights. This leads to my second voting issue. The Constitution prioritizes privacy. The Constitution, whether it's the precedent of the exclusionary rule or the fact that a warrant is required, shows that our founders and the judges who instituted this precedent were willing to pay the price of making some criminals go free because they saw liberty and privacy as the highest value in this round. Thank you.
All right, the judges are ready? Let's go back to the Larry Eiler example, because I think it shows us not only why punishing the guilty, but also protecting the innocent is best done with an affirmative ballot. You see, what the exclusionary rule did in that case, as it does in 55,000 cases a year, 1/3 of drug cases, is it frees the criminal without ever sending them to trial. Now, in his last speech, Caleb got up and brought up this 0.6 number again. And I know I didn't respond to this in my last speech, but what Caleb did in his last speech was change the meaning of this statistic. You see, in his original speech, he said that only 0.6% of cases were affected or changed or lost because of the exclusionary rule. But now he's saying that the exclusionary rule only has importance on 0.6% of the 55,000 or something like that. My response is he's changed the meaning. He's changed the meaning. You see, what I brought up, the statistic of 55,000, is cases that are never brought. These people who are released without ever being charged. His study talks about the cases once they're already in the system, once charges have already been filed. The whole importance of the exclusionary rule is that cases are never filed against these people. That's the important part. That shows you that the exclusionary rule is setting these people free, and half of the time they're rearrested within 2 years. And I brought to you the specific example of Daniel Bridges, a 15-year-old boy whose right to life, his right to liberty, and his right to property, because he's not alive anymore, were all infringed upon because of the fact that we prioritize liberty. You see, while prioritizing liberty, we're actually harming the rights, safety, and lives of all of society, not just the individual. Let's look down to his voting issues. His first voting issue was only liberty limits the government, and I'll be responding to kind of his arguments under his value of liberty as well. He talked about how justice bypasses liberty, and he said that criminal procedure, it wasn't important. I brought up how we're talking about within criminal procedure, not just all of society. My response is it's not absolute. The whole point of my response is talking about criminal procedure is that it's not absolute. Within society, we can prioritize truth-seeking, sure, that's great. But within conflict, that's what we're talking about. Outside of conflict, great. Knock yourself out, have as much privacy as you want, that's awesome. But when we're talking about criminal procedure specifically, and conflict within criminal procedure, we see that the applications and the instances of actual conflict I brought up were not responded to. Those instances in which we actually have to choose, we choose truth-seeking. We don't choose privacy, and that's legal under the Fourth Amendment. His second voting issue was the Constitution prioritizes privacy. My response is not in conflict. Not in conflict. Maybe outside of conflict, the Constitution makes privacy a general issue. But within conflict, it prioritizes truth-seeking because when a choice must be made, we choose truth-seeking. My one voting issue is justice does vote. Justice does vote. If you want to protect the rights, safety, and lives of people within society, then enforce the law. Don't use the exclusionary rule and vote for the affirmative.